So today, we're going to dig into a really important UK Supreme Court case. And it gets to the heart of a question that, most of us think we know the answer to, but we probably don't. It's a story that starts with a tragic 999 call and ends with a legal decision that honestly affects every single one of us.
Okay, let's just get right to it. Here's the big question. If you are in danger and you call the police for help, do they have a legally binding obligation to protect you from harm? I mean, it seems like the answer should be a simple yes, right? Well, as you're about to see, the law is way more complicated than you might think.
To really understand the legal side of things, we have to start with the human story behind it all. This case, which is known as Michael versus South Wales Police, it all began in the early hours of a summer morning with a phone call that nobody should ever have to make. And this is where it gets just heartbreaking, how fast it all went down. At 2:29 in the morning, Joanna Michael tells a 999 operator that her violent ex-boyfriend has just found her with another man, and he's threatened to come back and kill her. The call gets passed over to a neighboring police force, but a really critical detail gets lost in the handoff. The operator downgrades the urgency of the call and leaves out the specific immediate threat to her life. Just 12 minutes later, Ms. Michael calls 999 again. All they hear is a scream, and then the line goes dead. Police finally get there 8 minutes after that, but it's too late. They find her fatally wounded. So from this just absolutely devastating series of events, a really profound legal question came up. Could Joanna Michael's family hold the police legally responsible for failing to get there in time, for failing to prevent her murder? To put it in legal speak, the question was, were the police negligent? It sounds like a simple question, but it has a super complex answer. You see, for any negligence claim to even have a chance in court, the person you're suing must have owed you something called a duty of care. So what on earth is a duty of care? Well, think of it like this. It's a legal responsibility to act in a way that doesn't cause harm to other people. A doctor has a duty of care to their patient. When you're driving a car, you have a duty of care to everyone else on the road. But the huge question here was, do the police have that same specific duty to one individual who calls 999 for help? The entire case, everything, hinged on that one question. Now, before we get into the nitty-gritty of Joanna and Michael's case, we have to look at the law that was already on the books. And honestly, it might surprise you, because the courts had actually dealt with a pretty similar question decades before this. And this right here, this is the big one. This is the key precedent. It comes from a famous case involving the mother of one of the last victims of Peter Sutcliffe. You might know him as the Yorkshire Ripper. She sued the police, arguing they were negligent in their investigation and should have caught him sooner. But the court said no. And they established what's now called the Hill Principle, that the police's duty is to the public as a whole, not to any single individual. So you might be asking, why? Why would the courts make a rule like that? Well, it all comes down to public policy. The thinking was, if police could be sued by every victim of a crime they didn't manage to stop, it could lead to something called defensive policing. Basically, cops would make decisions based on trying to avoid a lawsuit, not on what's actually best for the public. It could also open the floodgates to an endless stream of lawsuits and tie up police resources that are already stretched pretty thin. Okay, so if that's the established rule, how did Ms. Michael's family even have a case to begin with? Well, they argued that her situation was different. They claimed that the 999 call itself created a special situation that kind of sidestepped that whole Hill principle. Their argument was actually really simple, but also really powerful. They said that when that 999 operator told Joanna Michael that help was on its way, the police weren't just protecting the general public anymore. No, at that exact moment, they created a specific relationship with her. They had assumed a responsibility for her safety. And this lays out this central conflict perfectly. On one side, you have the family saying that the promise of help was a specific promise to a specific person who was in immediate danger. But on the other side, you have the police saying, look, this is just a standard response. If saying help is coming creates a legal duty, then that duty would exist for every single emergency call. And that would basically destroy the Hill Principle and open up those floodgates the courts were so afraid of. So this case went all the way up to the UK's highest court, the Supreme Court. The judges there had to weigh the absolutely tragic facts of this one case against decades of legal precedent and public policy. Their decision, whatever it was going to be, would set the standard for police liability for years and years to come. And the decision was not a slam dunk. It wasn't even close. The court was split 5-2.
5 justices ruled one way, and 2 strongly disagreed. And that split just shows you how incredibly difficult and contentious this whole area of the law really is. There were powerful arguments on both sides.
In the end, the majority sided with the police. They ruled that no duty of care was owed to Joanna Michael, which meant her family's negligence claim had to fail. They stuck with the general rule that was set all those years ago in the Hill case.
Lord Tolson, who wrote the main opinion for the majority, he went right back to this public policy concerns. He argued that if they allowed this claim, it would force the police to make decisions based on whether or not they might get sued, instead of using their professional judgment to figure out how to best use their limited resources to protect the public as a whole.
But that is not the end of the story, because the 2 judges who disagreed, they wrote a really powerful dissent, offering a completely different way of looking at it, and it's so important to understand their side to get the full picture. So the dissenters, they basically said, hold on a second. They argued that the Hill principle was being used as a kind of blanket immunity, a get-out-of-jail-free card for the police, which was never what it was meant to be. They believed a duty should exist when the police are told about a specific and imminent threat to a specific person. And for them, this wasn't about questioning big-picture police policy. It was about a clear failure in how they did their job, a failure in the handling of that one crucial call.
And Lord Kerr's words here from the dissent, I mean, they're incredibly powerful. He said it was unconscionable, which basically means morally unacceptable, for the law to offer no help, no recourse to someone who is literally facing death, reaches out for help, and is then failed by the very system that's meant to protect them. So what's the big takeaway here? The bottom line is this. As the law stands today, because of this case, the police's primary duty is to the public at large. Their job is to keep the peace for the community as a whole. The law does not view them as a private protection service for any one individual, even if that person is in terrible, immediate danger. And that leaves us all with a really tough and uncomfortable question. I mean, of course the police have a moral duty, a professional duty, to respond and protect people. But this case confirms they don't have a legal one that you can sue them over if they fail. And it forces all of us to think about that fundamental relationship between us and the police, and ask ourselves, when we dial 999, what exactly is the promise that's being made?